Good afternoon. My name is Matthew Lidke, and I'm the senior writer at the Franchise Times, and I'd like to welcome you to another 2023 Legal Eagles Virtual Summit panel. This session is titled The Invisible Hand, Hostages, and Opportunism, Law and Economics of Franchising. This panel is sponsored by Goldstein Law Firm and features Jeffrey Goldstein. It also includes commentary from Craig Trattenberg of Fox Rothschild, David Kaufman of Kaufman, Gilden, and Robbins, as well as Robert Emerson of the University of Florida and Adi Ayal of Bar-Ilan University in Israel. I'd like to now hand it over to Jeffrey, who can give you more insight onto this topic.
Thanks, Matthew. Today we're going to be having a short discussion on some of the common economic issues that permeate antitrust and franchise law. We all know the nuts and bolts, and there are many panels that will discuss those. Here today, we're going to be discussing some concepts and theories that are ancillary to those concepts. Not all of the issues will necessarily be addressed by each of the panelists. They have an option not to address these issues. We hope they'll participate. There'll be no order that I call on people with regard to answering questions. There can be questions asked between panelists. There's no problem with that. And there's no particular order in how I'm going to present the questions. And I will note that we've got a very tight time schedule for many of our panelists that have personal matters after this. So I may be pushing people in answers and possibly cutting them off, and I certainly don't mean to do that intentionally. So let's start right off with one issue that I would call a general one of antitrust law and how it impacts on franchising. It's clear to me that since the early 1980s, antitrust law has lost its ability for plaintiffs probably across the entire United States, and certainly with franchising, with the Legion case and the American Needle and tying, and I'd say maybe with an exception of tying. With the new antitrust czars who have come in, Jonathan Cantor and Lena Khan, at the DOJ and the FTC, it seems to me we're headed for, I would say, a rocky road for many reasons. We've got a neo-Brandeisian sort of theory or a hipster antitrust program coming in. And I'm wondering what the panelists think is in store for antitrust plaintiffs who are franchisees. Whether you think the new administration may start to hit up against some of the traditional 1980s types of vertical restrictions laws. Adi, do you want to start us off on that?
Sure, thank you. So I would move away from descriptions such as hipster antitrust. I want to kind of delineate that into a few different streams, if I may. I think that the difficulty is that we have two things going on at the same time. At one side, antitrust has been moving towards more economic analysis. I would say case-focused economic analysis, which requires plaintiffs to have a lot of information, not just economic theory, but relevant factual information about the case they want to bring. And this is true for most of antitrust, not just vertical relationships. On the other hand, what I think we should be talking about is how much of the vertical issues in franchising are about what you called opportunism. But we have to look at both sides. So basically, we see one side of protecting franchisees from the franchisors. And we see that in good cause termination agreements, for example, or good cause statutes in some of the states that enacted these. And on the other side, we want to protect the franchisors from franchisees who just don't put in enough of the effort and kind of free ride on the brand name which they have been given. Now, it's easy to go and say one side is more to blame than the other, but I'm a very ardent fan of case-specific analysis. And I think the only way to do that is to delve really into the economics of each case separately, which is fact-intensive and difficult for plaintiffs, but I think mostly necessary.
Let me follow up for 1 second on that. In your vertical sphere, franchisors have gotten away for the most part because there's no market power. There's been a finding of no market power. Under the new regimes, whatever you want to call it, under Cantor and Kahn, horizontal guidelines are due to be issued soon. And Cantor seems to be intent and Kahn going back in time to 1890s when the Sherman Act was devised and passed, and looking at legislative history rather than all the development and the Reagan economics in the early 80s. So, isn't there a possibility that a new way of looking at markets or a new way of looking at competition would impact the vertical area, such that a market could be defined that would allow a franchisor to be a defendant? One of the most notable for me is the lock-in under Kodak.
Exactly.
And that's never been really developed, I thought. It could pretty much move along the whole spectrum. But what do you think about that?
So people have been relying on Kodak and the idea of protecting locked-in customers for a long time. And it's one of those things that is easier to do in theory than in fact. So you bring a specific case and you have to delve into that. I think the requirement for market power, the true antitrust test of market power, is really difficult to implement in franchise agreements, because it's kind of obvious the franchisor will have market power over his franchisees. They have very little ability to move away. Usually they've invested a lot, not just in capital, but in their own human capital as well. So saying they're locked in is almost always true. But does that mean that they didn't realize to begin with where they stand, or that the franchisor is taking advantage of them? I think these are much more difficult to prove. And maybe one statement about that, I think using antitrust to target franchise agreements is kind of using a very big hammer for a more detailed, nuanced nail. And maybe a direction to go should be that the FTC looks at franchise agreements separately and understands these are not normal vertical relationships in antitrust. They require more, I would say, detailed knowledge of what goes on in franchise agreements.
Thanks. Anybody yet? David, you're an old antitrust guy.
Well, what I was thinking is, Kodak sort of cleared the path for franchisors, because the lesson to be learned from Kodak is if a tie, otherwise illegal, is disclosed up front, then it becomes legal. And franchisors have ample opportunity in their disclosure documents to make clear what must be purchased from the franchisor or its affiliates or its designees. So there's no element of surprise on the franchisee side. They can claim elements of surprise, but there is none.
Right. Great.
I'd like to open the antitrust argument or have a thought experiment. Could there be such concentration in franchisors collecting so many brands that there's a barrier to entry in the franchise business as to particular segments? So let's say that two large private equity companies each were sponsors of 20 franchisors each. And they controlled initial franchise fees and a lot of the sourcing in the franchise relationships. And now a new franchise brand, McBurgers, wants to come in. and finds that it's having problems with sourcing, it's having problems with getting franchisees because the other consolidators have multiple hamburger brands, and franchisees of the consolidated brands also claim that they've been hurt by the concentration. They can't go into the territories that they want because the franchisor's other brands want to exploit those territories, and it's just not good for business. Does anybody see a world in the future where consolidation of brands could create antitrust issues?
Rob?
Yeah, I would say that from the perspective of students of mine, which may not be a good perspective, I teach hundreds of students. And so I try to do things to liven it up. So I'll talk about franchising because that's something I know about. And they'll think of sports. They'll think of sports franchises, and things like the Gators. And when I tell them what I do research on, they immediately start thinking of brands. They are in a social media culture. And so I think intuitively, the arguments that I've heard here or the comments I've heard would resonate with intelligent but somewhat ignorant of the particulars of franchising people at, say, the University of Florida, future business people, future law students. And so what Craig is saying to me makes a lot of sense, that if you get massive enough in terms of different brands, you start having a different argument than if it's just that sort of the theory we're used to thinking of just this sort of vertical structure of franchisor, franchisees, and consumers. Having said that, I will point out, and I'll give it to somebody else, I have not written much on antitrust law. My one big foray into that was way back in 1993 in the Florida Law Review, of all places. And it was on tying, it was on Kodak, and it was on the Krell case dealing with tie-ins. And then I guess I got scared, or I got wise maybe, and I've written, many, many other articles since, but I've tended to go away from antitrust. My assumption has been that antitrust was what got the Forum on Franchising started so long ago, what got people into antitrust law back in the 60s and 70s. And then at some point, most people went in different areas, and it's more people like Adi maybe, and maybe Yuri and others who've written about this, certainly more than I, that maybe are, from the academic point of view, bringing people back into it.
I'd say a quick note to Craig. If this was 2 years ago, I would say there's not a problem. In a sense, it's sort of like a conglomerate. It could be argued it's a conglomerate. And I think you'd have to look at the relevant market. You'd have some markets isn't really used anymore from the 60s. I think you would have separate markets. You'd have independents all over the place. And I think the key would be entry barriers. I mean, you've got independents who would comprise each of those separate markets. And, unless there were just some type of input you mentioned that just had incredible economies of scale, where that would be an entry barrier in and of itself. Somebody else couldn't enter in that way. But it's hard for me to see that under the law 2 years ago. But given the way people are talking now, and we haven't seen those horizontal merger guidelines, and given how I think it's a little bit crazy to take the law, turn it upside down, and go back to 1890, and then start reading the statute from a textualism point of view to see what the words say, I think that's a little bit nuts too, no matter what side of the aisle you come across. Adi, do you have a view on Craig's side?
Yeah, I thought Craig's point was really interesting, and it, from two perspectives. First of all, there's been a lot of work in the antitrust world just the last few years about aggregate concentration, which has not been discussed for a few decades. And just the last few years, there was a big paper by Azar and others on the airline industry, basically describing a kind of holding company scenario similar to what Craig was describing in franchising. So from that point of view, I think it's really interesting. And if I want to combine that with what Robert said about the use of antitrust and your mention of entry barriers, think of these holding companies or private equities. If they have some sort of hold on an input, now input can be financing, which is difficult to argue that it's very concentrated and probably can bring other sources of financing into it. But think of the different brands that these private equities might be holding and the competition between the brands, because these are not totally integrated structures. Oftentimes, private equities will hold some percentage of each of these brands. So the brands find themselves held by someone who has some commonality, which basically wants to create a form of horizontal agreement not to compete or to compete in very specific ways. And that could be really interesting from an antitrust perspective, but it has to be pretty concentrated in order to pass muster, just to get beyond the initial motion to dismiss.
Well, wouldn't these need to be substitutes to some extent? I mean, I think maybe we're assuming that the brands are substitutes. How could they conspire in a way to raise prices if there's no substitutability between them? I mean, they're really not separate markets. I mean, what kind of are you going to look at some sort of foreclosure argument with regard to supply, maybe, or inputs?
Sure. I would think that's the direction you would go. And you could look at it from one of two ways. Either you're talking about brands that are relative substitutes. Think of two burger franchises for a very simplistic way. Okay. But another way is to look at, do those private equity firms give something other than just financing? Because if they give supplier relations, and if a lot of the inputs for the production of the local franchise, think of the types of things that the franchisees need in their shops. And it could be food stuff, it could be logistics, it could be sourcing of material. A lot of these different types of franchises actually use similar suppliers for a lot of what they need. I, as a consumer, want to go and buy the food, but in order to get the food, someone has to have provided not just financing, but real estate and the logistics and a lot of things that are kind of common across different franchises.
Makes sense. I'm going to shift gears for a minute. If people have ideas as they come to them that run a prior issue, it's not all that formal the way I like to run this. So feel free to bring it up. I wanted to look quickly at the information problem in franchising. And the way I look at franchising is that there are three main problems. You can look at them as neoclassical or transaction cost or agency principle. The three that I pull out are adverse selection, moral hazard, and idiosyncratic investment or specific investments. And opportunism is woven throughout these as well. The FTC is now looking to expand or modify the disclosure on what franchisors are required to provide to franchisees. You know, I'm at the point where I don't think that the disclosure of information has that much to offer in terms of marginal benefits for curing those three defects. And I know that's a lot to put in one sentence. But it seems to me with all the cognitive defects and things that have been discovered, the way consumers, which are franchisees, the way they view this, it's not a simple neoclassical assumption. We're just going to pump more information into the market, and it's going to work properly as long as the other assumptions are met. And we've tried. I mean, how many years have we been doing the FDDs, and there's always the fighting about what goes in the FDDs, and it doesn't seem, from my point of view, it's very anecdotal of looking at how franchisees view these things. I don't think there's that much more of a benefit that can be obtained through the FDD, although people love to send comments and etc. So I'm wondering if you agree with that, and if you do, what alternative types of there has to be government regulation. Do you think would fix some of those defects, the adverse selection, the moral hazard, and the specific investments?
I would submit, Jeff, that the current mode of disclosure violates nothing and helps franchisees a great deal. I'm not saying the disclosure format today is perfect. It isn't. I have been advocating for many years, both publicly and in private, to the regulators. I served for many years as their advisor. That the number of franchisees who actually read the franchise disclosure document is minimal. They may read sections of it, but not others. They'll go to item 19 for financial performance representations. But I've been advocating a long time that we really should be going to a video-based disclosure platform. That being said, you know, you have to compare the franchise arena with the securities arena. And if you notice, in the franchise arena, there have been very few what I would call fundamental frauds over the last 40 years. They do pop up from time to time. Just last year, or was it now 2 years ago, sorry to pick on Israel, certainly, but it was Burgerim, B-U-R-G-E-R-I-M, Burgerim out of Israel, that sold franchises in a not entirely wholesome manner, shall we say. And eventually, the state of California stepped up quickly, shut them down, took $5 million fine, and that was that. But other than that, in the franchise arena, disclosure has done much to keep it clean. Now, compare it to the securities arena, where it seems every other year we have a major fraud. Last year it was crypto, a number of years ago, a decade ago, it was Madoff, etc. These disclosure documents seem to go a long way. They may not be read entirely, but they're read sufficiently for franchisees to be able to make an informed investment decision. And so I really wouldn't toy with the idea of illuminating those documents. I think they're very helpful for prospective franchisees. And we lawyers who have to prepare them, not only do we have to make sure they're true and accurate and complete, but we also have to make sure that they're written in plain English that anyone can understand, because, you know, at one end you may have very sophisticated franchisees building luxury hotels, but at the other end you'll have franchisees coming into lower end franchises, be it 7-Eleven or Janet King or something like that. And so the documents must be in plain English, must be readily understood. And I think they've gone a long way to keeping this marketplace pretty clean. And you're talking to somebody whose introduction to franchising was as a member of the organized crime task force. So
but you're talking about clean, right? Fraud. Fraud is something a private entity can fish out for himself. I'm getting at something a little more esoteric, that there are market failures, okay, moral hazard, where the franchisor is able to use its guile and act in a way that's counter to the franchisee's efforts, and it's on both sides. But that information, if it's not read, if it's not assimilated properly, you may have a beautiful FDD. I know you were doing them the other day, but how does that impact the market? That's what I'm concerned about from an economics point of view. If it doesn't impact the market and there's a defect, it's a cognitive defect on the part of the franchisee, then it's useless in some sense. Yes, there's some benefit. You can get a big fraud. It didn't stop burglaring at all. But I just don't see how it I think there are better ways to prevent the market failures. I'd almost be in favor of gutting the whole thing, the FDD, in exchange for having a statute that said the franchisor must act reasonably in creating the franchise system, operating it, and bringing it out. I think you might have more, less allocative loss with that. But I respect your decision. A lot of people have that view. I just don't think it has that much left to it.
I think what you're talking about from my study in sort of comparative law is you can go to a number of countries where it seems like the approach is much more you fill in the niches through the jurisprudence and through the understood standards, and you don't have as much of a statutory base or a precedent base, but much more, I think, closer to that sort of what's reasonable, you know. For instance, in a lot of countries, they have the notion of savoir-faire or something else along the lines of continuing provision of information, skills, and other things from the franchisor to the franchisees, and it's built right into the jurisprudence, the expectations. So a lot of the test is more not at the transactional level initially, but more the relationship going on. And the only thing I'd say to David's point, which I think were very, very good, and I understand them, and I think I've become more nuanced as a professor and a researcher over the years, because I remember initially just thinking, you just have to tell people more. And as you get into it, I'm no psychologist. You see all this cognitive biases and all the rest. What concerns me is, even though there may well be a lot less systemic sort of fraud, it's for each of these franchisees who get bitten by their confirmation biases or their failure to read or whatever it is, there is sort of that moral hazard, I think, that for franchisors, as long as the law protects them, they don't constitute fraudsters. They've got a parole evidence rule, which may make them fairly well protected. They have waivers that have been signed and the like. You set up a system where it's fairly easy to not necessarily, I think, worry too much from the legal angle about people who are going to be making mistakes. There may still be impediments to that simply off of, I've always assumed that for most franchisors, certainly if they're acting in good faith, they don't want foolish people to be franchisees. You know, they know that it's long term and it's probably not in their best interest. But up front, legally, I think we have a system in which we know about the problems with disclosure. We know about the problems with some of our laws, which I think are very much oriented toward what's in the contract, express or implied, and, you know, not all the other stuff that we associate with it. And that's where I have some problems with sort of that. I like your approach. It would really throw a lot of people for a loop, wouldn't it?
Craig, you've been watching.
Oh boy, I got a lot here. First, to David's comments. Thank you for using the analogy of Securities and Exchange Commission rules with the franchise, with the FTC's disclosure rules. There's a big difference, though. The SEC imposes strict liability on the securities perspective, but there's no private right of action under the FTC rule. So we have a patchwork quilt of state laws that have anti-fraud provisions. I'm not suggesting that we should move in favor of what the SEC has, but there is a concept of maybe moral hazard because franchisors don't have the same obligation as issuers of securities in the United States. So put that aside for a moment, because I'm going to get to both Jeff's comment and David's comment. Isn't the FDD substituting words for reality? Aren't we really saying that there's no duty of competency by franchisors that's really enforceable. And that's what a franchisee should be looking at. Is this franchisor competent to provide shepherding over the investment of my life savings? Can I trust what they're saying they're going to do? That's not in the FDD. There's it talks about some of the factors, but the franchisees don't go to visit. Forget about reading the FDD. How about calling the franchisees that are listed in the FDD and asking, what is your experience with the franchisor? Can we rely on the item 7 for cost projections and how much we have to invest? Has your location succeeded like the item 19 franchise financial performance representations? Most franchisees don't do that. What they do is listen to the last person they talk to about the franchise. Maybe they visit one, maybe they don't. Maybe they envision this is what they would like to do. And sometimes they have too much reliance on the numbers and the words of the FDD and not enough experiential experience with the franchise itself. So those are my comments. Thank you for listening to me.
Yeah. And those are all biases which are plenty of people have written about, including yours truly: anchoring bias, reactance bias, confirmation bias, information bias. The key word is the bias of the mind, which we all have, and which sadly it turns out the information bias is personally maybe my favorite. It tends to say seeking too much information can be just as much of a problem as not having enough.
Yeah. Great. Going to another franchisee and trying to fill in the gaps of whether there's competency. I can talk in extremes. It's utterly useless. Putting aside where the franchisors gag franchisees after there are problems, and putting aside that many franchisees just don't want to share what I view as some of the most pertinent information that they should get. Why don't franchisors, let's not have an option on item 19. What's the most important thing, common sense, that somebody would want to have, all right, when you're buying a business? You want to see the profits and losses. And franchisors, well, we can't do it because of this, we can't do it because of that, we can't do it because of this, we'll have liability. That's the main thing. Why are we modifying these 22 items? I would take, if you could put one item, the one item you'd want to know is, of the system, how many made a profit and for how many years and what were the costs. I mean, one page would be more useful than the 500 pages that I have to look at for a franchise. I mean, do you disagree with that?
Well, I think that you can cut the. I don't hold myself out as a disclosure lawyer like David, but you can cut that item 19 virtually any way you want these days. I mean, I wouldn't say that there's no rules, but there's a lot of creativity in getting to truthful presentation of the information, which helps the franchisor. And it could be as simple as that, I guess.
But the idea, Jeff, of having mandatory profit and loss can't work. And I know you said it sounded like an excuse. It isn't. Franchisees very often, first of all, the numbers we get from them are the numbers we get from them. They're not audited. But let's assume they're truthful. Many franchisees will show zero profit at the end of the year just because of tax-based operations. They're not going to leave money in the pot at the end of the year. They'd rather distribute it instead of paying taxes twice. That's tax avoidance. And we all know the difference between tax avoidance and tax evasion, right? The answer,
Maybe we'll find out tonight.
the answer is 5 to 10 years is the answer. No, but
well, why can't the state? I'm jumping in. Why can't the statements be made? We don't have to use the accepted financial statements that are out there.
But I'm saying franchisees won't show profits. Many of them will show zero profit at the end of the year. It doesn't mean that the owners didn't take out massive dividends to bring the profit number down to zero, so the tax hit is eliminated. But it does mean that if you're just going to go by technical numbers on net profit, you'll see a lot of zeros, which is prejudicial.
It's also problematic in startup franchisors that don't have franchisees with a lot of time under their belts and may not have an analog franchisee to show profitability for. So that might actually overburn the new franchisors, where the franchisees have to be even more careful.
Well, I have a question for, I guess, the practicing lawyers, which would be 3 out of 5 here. I was at a congressional committee Zoom conference, and they interviewed a bunch of people that were called as witnesses. And one of the proposals was to have, mandatory disclosures, have the FPR 19 be required. And in studying it, I came across, it's nothing novel, other people have been writing about it, the notion that the failure to disclose is more informative than if it were all mandated, because a lot of franchisors do disclose things. And if a franchisee takes the trouble to look into it, or potential franchisee, he or she will kind of go, well, why are they not giving me this information? And that's more important than just having everybody provide it. And I wonder what your perspective on that is.
Well, mine is simple. Right now, the latest number from FranData shows that over 2/3, it's closer now to 70% of franchisors do feature financial performance representations in item 19 of their franchise disclosure documents. And Robert, what you just said is spot on. I mean, look, those of us who are in this day after day, we don't counsel franchisees, we counsel franchisors, but others here counsel franchisees. And I know what their answer is, because it's the same answer I give when people say to me in their individual capacity, relatives, friends, I'm thinking of doing this, but there's no item 19 disclosure. What does it mean? And the answer is, it means the numbers stink. and that's pretty much just affirming what you just said. There may be more of an impact for no 19 disclosure. And the 19 disclosure that exists now was very much fine-tuned about 4 years ago now. And I was on the subcommittee. There's a government group called the NASA Franchise Project Group. It's all the state franchise regulators and the FTC sitting ex parte, and they have a very few outside advisors. And I'm one of them, and I was tasked on the subcommittee of revising, or not revising, but creating these guidelines, which are really picayune, to make sure that item 19 is fair. So, for instance, some franchisors used to cherry pick. They would take the top 10 units in the system and feature their numbers. Well, now under this new statement of policy, if you take the top 10, you also got to put in the bottom 10. That's just one example of a great number of refinements that were effected to make sure that 19 is as factual and data-based as possible, and not skewed to misrepresent the picture.
Let me jump for a minute to another issue. I know everybody's got to be places, and I apologize. All these points are things.
Can I stop you one moment, Jeffrey? Because I thought you brought up something a little bit broader, and we went into the financial representation, but your question at the beginning was broader than that. And what I heard you say is basically that you want to look at some form of ex post analysis of the behavior of the franchisor and the franchisee. I would go both ways, rather than just have these clear-cut ex ante rules that have to be procedural. And what David was just mentioning was bettering or improving the procedural aspect of financial presentation and that's true of other presentations as well. But I think the main question is, how much can we rely on these ex-ante procedures when franchise agreements are so different and franchises are so different across different industries, and there's so many franchise agreements that are not even in the service industry, not food service, hotel service. These are the obvious cases which we all know, but there are so many franchise agreements within industrial relations, just marketing of industrial products, which normal everyday consumers don't even hear about. And the question I would have is, how much do we want courts to come after the fact and examine a specific complaint that franchisees have about their franchisor because he took advantage either of the biases that you were talking about, and it doesn't have to be any, newfangled psychological biases. It can be just the basic bounded rationality that comes from over-information, Herbert Simon style. But more than that, what you're bringing up is a question of kind of the duty of fair dealing. So how much do you want courts to analyze fairness after the fact based on the specific circumstances of plaintiffs that want to argue their case?
Well, I think it has to be a lot, and here's why. I think the moral hazard problem, another way to look at it, is the opportunism on both sides. Franchisors have already accounted for, in my opinion, the opportunism of franchisees. They have a lot of monitoring. You can be terminated at will in many places. Even the good cause can be trumped up. So franchisors have a lot of control over that opportunism. The opportunism that's coming from the franchisor, okay, that's a much more difficult. It's not written about in the literature. It's not defined very well. Even the concept of opportunism is not written about very much, except maybe a reasonable person looking as to what another reasonable person would look at. So I think it's rampant, and I think it needs to be looked at. And the only way, well, I shouldn't say the only way, the one way, the offset would be a covenant of good faith and fair dealing. And I think that's under massive attack. When it first started out, you had the covenant of good faith and fair dealing. Sometimes it had its own cause of action. It stood independent of a particular provision in a franchise agreement. It's now been pulled back by the judiciary in almost every state. Some states don't even have it, except for the UCC. And it has to be put to a piece of discretion in a particular provision. So it's not just a franchisee lawyer lamenting, oh, there goes the covenant of good faith and fair dealing. It forms a nucleus of the ability to get the market defect. The opportunism is a market defect by franchisors. And if courts have to look at it, then they have to look at it. And I think courts don't have that much of a problem. I think there should be maybe some more experts in franchising. The problem with me saying, yes, the court should do it, is that franchisees usually don't have the resources to fund a case like that, never mind the one expert who would be called in for something like that.
Sure.
But the loss of the covenant of good faith and fair dealing, it's an absolute disaster from an economics point of view, not just a franchisee.
And we know that in almost any area, if there's a contract term that seems to be pretty strict, many people will read that. They'll finally read their contract and they'll finally go, oh, I can't compete, or I can't do this. The terrorizing or interorum effect is there. And I'm not saying that's anything other than good contracting on the part of the parties, but it is that issue of you have the transaction and then you have a long-term relationship. And then finally people are, after maybe many years, they're looking back all the way to the initial stage, and that's being used without accounting for all this in the meantime since then.
Sure. So this is something we could also learn from antitrust, because the movement from per se to rule of reason analysis created exactly the type of problem you're talking about. Plaintiffs have a very hard time of bringing a case, regardless of the specific argument that they're making, because it's expensive, it's difficult, it's fact intensive, and you need patience, time, and money.
Exactly. You know, we touched on the good cause statutes and the state statutes that are around. And what was interesting to me is I look back, and I don't have a lot of faith in legislators knowing what they pass and if they understand even what the words mean. But a lot of these state statutes say that they've been enacted to correct an inequality of bargaining power. And people look at that word bargaining power, the term bargaining power, in different ways. There's different kinds of power. There's market power in an antitrust sense. There's power that comes out of contracts, that where you've got a specific investment where you can hold somebody hold up in a contract. And there's different kinds of power, and there's different concepts of what is bargaining power. Is that necessarily all wrong, all right? Is the fact that the franchisor writes the entire agreement, it's a contract of adhesion. Is that an indication that there's something anti-competitive? Is that market power? Is that bargaining power? I think there's a lot within the franchise bar. I'm not sure people could sit down and define what this bargaining power means. What is this? I think a better way to go at this is look at the market defects. I think there needs to be a better definition of what opportunism is, especially fleshed out on the franchisor side. Not because I'm a franchisee guy, because I'm just looking at the literature. It's just not developed. And to move from there, the concept of bargaining power and then courts interpreting these state statutes saying, well, we're going to go back to the legislative history and it talks about bargaining power. And if we have an antitrust case, there's no way we can figure out what a relevant market is. And it seems to me that the state statutes are a bit of a mess in terms of theory. I don't know. Does anybody have a comment on it?
Oh, I have a comment on that. As you might expect. First of all, I wrote one of those statutes.
I know.
The New York Franchise Act. And here's the truth of the matter. When these statutes were enacted, the first statute was California, 1971. The last was mine, New York, 1980. FTC was 1979. This was a very different era for franchising. At that time, franchising accounted, plus or minus, this was then the Department of Commerce, for roughly 15% of retail sales in this country. Now, fast forward to today, it accounts for over 40% of retail sales in this country. Every time you buy a car, every time you fill it with gas, every time you have it repaired, every hotel, all quick serve restaurants, mid-level restaurants, even very high-end restaurants, lawn care, tax prep. I mean, you know the list. It has dominated over the last half century, as have franchisees. Franchisees are not the single mom and pop operators that they were when these laws were enacted, and there was an imbalance of bargaining power. Today, according again to IFA, the Educational Foundation, over half of all franchisees have more than one unit, sometimes 5 units, sometimes 10. Takes the largest franchisee owned by private equity. It's not owned by private equity anymore. It's Flynn Restaurant Group. They have 1,300 Pizza Hut restaurants, 350 Wendy's restaurants. Their bargaining power is quite significant, I assure you. And so the early legislative language about the inequality of bargaining power and the judicial repetition of that language, it doesn't hold water anymore. And we're up against it right now in a very significant federal action on behalf of a very major hotel franchisor. The franchisee is claiming he's, as innocent as a newborn babe, and he already has 7 hotels that he's developed, and he and his family are extraordinarily wealthy from them. It's not the same as it was, and these legislative pronouncements about the inequality of bargaining power, those are historical now. They're not present tense.
You have no application in your opinion. There's the concept of unequal bargaining power.
No, I'm not saying there can't be instances of unequal bargaining power, but overall, the franchisee population has become remarkably sophisticated. In fact, Jeff, as you mentioned, or maybe it was Adi, excuse me, many franchisees are owned by private equity who are hardly unsophisticated. They may own 50 Burger Kings and 40 Pizza Huts and et cetera, et cetera. It's not the franchisee population is not what it was when the statutes were drawn.
Do you think that the differentiation between sophisticated and unsophisticated would help in that area? Are there areas where you could label someone unsophisticated and okay, they're not part of the massive multi-unit franchisees, let alone big chains of hundreds of franchises, but the proverbial one that people think of going all the way back to the 70s, saying that person was unsophisticated, they need something more along the lines of maybe what Jeff may have been talking about.
I don't know, because at the end of the day, once you try to quantify what amounts to sophistication and what doesn't, that's a trap door. And you may not be sophisticated from a certain perspective. Let's say you're looking to buy a quick serve restaurant, easy example. You may have no experience at it, etc. But you may have made a fortune running a business. For instance, I always point out my HVAC guy, heating, air conditioning, plumbing, etc. This guy could buy me and sell me 20 times over. He has run a business, expanded that business over the last 25 years. It's been a remarkable success. Now, if he comes and says, I'm just a guy and I want to buy a QSR, quick serve restaurant, and I have no experience in it at all, is he unsophisticated? I would doubt it. When it comes to business, he's quite. And so anytime I hear about inserting notions of fairness, including the implied covenant of good faith, okay, which is just another notion of fairness, that don't come with definitions, all right, but are malleable, I get very concerned.
Yeah.
So let me jump in here for a moment, because teasing apart which parties are sophisticated and which parties require, let's say, assistance ex post facto from the judge. This is something that can and I think should be decided on a case-by-case basis. I would feel very uncomfortable about treating all franchisees as either unsophisticated or saying that they're today different and they require no help from a fairness notion. The whole idea of an ex post analysis that a trial court will do is in order to look at the specific case of this franchisee and franchisor and ask, what mold do they fit? Are they ones of a large corporation versus an individual who doesn't really know what he's doing on one extreme, or is it somewhere else on the spectrum? And these types of parties, I think, deserve different types of legal rules protecting them. They're not in the same situation. And if I may, one thing about the good cause statutes on a state-by-state basis, I did an analysis of this a while back, and I tried to look at what do these good cause statutes do relative to the performance of franchisees. What I was looking at, I wanted to see, do they interfere with franchisor control of franchisee opportunism, which is the standard argument. And the way I looked at this was together with Uri. The way we looked at this is we took the case of hotels, franchise hotels that serve non-repeat travelers almost exclusively. So one-time travelers. This is the case where you would assume that there would be opportunism on part of the franchisee, because there's almost no market control of what they do, no reputational mechanisms. And we found that there are no significant differences between franchisees in states with or without good cause statutes. Or in other words, the good cause statutes were not causing more franchisee opportunism. No, I'm not sure what they were causing and how much they were improving other aspects, but they were not a big problem for franchisors, at least if we looked at what the data told us.
Yeah,
so if they have another benefit, maybe that's worthwhile looking into.
Yeah, I had a study somewhat along the same lines in Wake Forest Law Review, and we looked at, in effect, court decisions and their rationale, their reasoning, and who they held for franchisor or franchisee. And I think we came to some of the same findings that you and Yuri did, that it's really hard to predict based on the statute if the court actually gets into examining the actual facts of that particular case, which leads me to the one big issue, which everybody's probably aware, is just the whole cost of that. The whole to get through all that discovery, to have a perhaps just result, maybe requires so much time, as you said, patience and money to get there.
Sure. Although what I would like to see is not just what the court did in the end, but how much this affects the bargaining between the parties,
okay,
which is almost the whole story. I mean, what courts do is the very small part of that story.
Yeah.
So here's my issue with good cause statutes. And let's say that I'm talking about a state that gives evergreen franchises to people. That is, they have franchises in perpetuity unless there's good cause for termination. I, as the franchisor manufacturer, have a wonderful product, and I have a well-established franchisee who is not exploiting the brand as well as I would like. And I would like to eliminate that franchisee and go in there myself or get someone who's stronger, because I'm losing a lot of money in that state. But I can't, because I would, even if a court would allow me to pay off that franchisee, the margins for doing that would be such after litigation and so on that I really can't exploit the product as well as I should be able to. Now, I do want to compensate the franchisee, but I can't. The court has tied my hands. Does anybody have an answer to that problem?
Yeah,
I would say that's the extreme case.
Well, how extreme is it? It happens every year.
Oh, sure,
to somebody else, a different franchisor.
Adi, I hate to tell you, that's not an extreme case. I can give you the most ludicrous case that we're handling now, and I can give you another example of how these good cause. Again, by the way, quick background: these laws governing termination and non-renewal, again, a half a century old, and the reason they were passed is that in the early days of franchising, some opportunistic franchisors would establish franchises in regions nobody ever heard their name before or knew of their product before. And franchisees would build up the name, build up the product, get a customer base. And then these ne'er-do-well, and there weren't many, but there were some, these ne'er-do-well franchisors would say, I'm not renewing you, or I'm terminating you, and then go in and take over the already established new customer base and name recognition and so forth. But that was then. This is now. If you have a contract, first of all, termination, non-renewal, that's governed by the contract. And if both parties freely and almost always with advice of counsel enter into those contracts, these good cause laws can drive you nuts. I'll give you a radical example. All right. A very well-known convenience store franchisor, you all know who it is, needed to terminate a franchisee in Connecticut who was operating a really filthy operation, just bad. And so, but Connecticut has a 60-day notice requirement for termination. So the franchisor was compelled to give notice of termination in 60 days. In those 60 days, that franchisee took everything out of that convenience store. And by the way, in that system, the franchisor buys everything, all the inventory, all the lottery cards, all the, at the time, videotapes, everything. Sold it out the back door, stripped the store down of all the inventory that the franchisor had purchased. And you say to yourself, well, what can the franchisor do? They had to give 60 days notice. There was no way around it. And this is one of the unintended, but certainly ill effects we managed to get justice done in that case by advising the franchisee. There's one thing, there's such a thing as franchise laws, and there's the other thing, Connecticut statutes against grand larceny. So, want to do. But these laws can trip you up. And there's another one now, that New Jersey law, which, as Craig says, pretends.
I didn't say New Jersey, did I?
You didn't have to. You didn't have to. The one that where the New Jersey Supreme Court said it confers an infinite franchise. First of all, that was in dicta.
That's a great law. I love it.
But the idea of it, that's correct. You have a hotel franchise, let's say, for the next 500 years. These statutes have outworn their efficiency. This all comes down to contract. And one other thing I wanted to mention, Adi, when you're talking about unsophistication, those of us who try these cases know, and it's always been the case, when you go into court, within the first 5 minutes, the judge and or jury is going to form a view of the case. Who's wearing the white hat? Who's wearing the black hat? Who's the good guy? Who's the bad guy? Or the good woman or the bad woman, as the case may be. If you get a really unsophisticated franchisee in court, the judge and the jury are going to lean over backwards to try to help that franchisee if that franchisee deserves help. So it's not a matter of, less sophisticated franchisees don't fare well in court. They may fare better in court. It's clear that they're unsophisticated.
And David, I want to Adi, I want to interrupt you for just one moment, because we're talking about legislation. In California, the regulators have expressed a preference that every termination case should not be resolved by summary judgment, but that it's their goal under the regulations that they have propounded that every case come to a decider of fact. That summary judgment is not what they anticipate, nor do they want it, because everything is so fact specific. This pronouncement by the regulators has been suggested to be improper, because that is the goal of the legislature and not the purview of regulators. Nevertheless, this is where I believe California is today. And so California may be one state, there may be another state that follows a similar system. It's not only legislation, it's not only, it's the application of the rules by the regulators.
Do you think that that franchisees would need the help of the good cause legislation if there wasn't an immediate termination requirement in many franchise agreements? Why is that necessary economically, to have incurable defaults and terminations? Now, I'll give you one answer. Could be that we need the terminations to prevent opportunism, so the franchisee knows that you shouldn't act opportunistically because you can nail them with a termination. My question, and there's very little literature on this, is how much does that termination have to cost the franchisee? A lot of the literature just says, well, we just need the franchisee to know, and if we tell him he's going to be terminated, he'll definitely know. Why do we have to have it definitely know? Why doesn't he get paid half his business? If you want to get rid of your guy because he's not operating efficiently or up to standards, terminate him and then you pay him for something. No, what happens is it's rare that they get paid. And if you have a good franchisor, they let the franchisee resell. But the concept of a complete termination and its evil brother, the incurable default, okay, those are things that don't make sense even economically, because they don't lubricate anything. It's overkill, if you know what I mean. But every iteration of a new franchise agreement, the incurable default is now this big when they used to be this big.
Well, Jeff, let me respond to you real quickly, because we're talking about one of my favorite states, New Jersey.
Right.
New Jersey has a franchise in perpetuity unless there's good cause for termination. And if there's good cause for termination, there's a 60-day notice requirement. However, by judicial fiat, certain incurables, certain defaults are incurable and don't fall within the statute. For example, under reporting, there's a New Jersey Supreme Court case that says the statute, the New Jersey Franchise Practices Act, is intended to protect good faith franchisees performing their agreements. It's not intended to protect criminals. So if you catch the franchisee under reporting, termination, that's an incurable default. Termination is appropriate. The act doesn't apply. On the continuum, there are franchisees in New Jersey who underperform. And the 60-day notice, advance notice, is to allow them to get into court and sort of deal with that issue, maybe by injunction, and maybe mediation. And the New Jersey cases seem to really enforce the statute, because the statute defines good cause in a very precise way. It requires a material default by the franchisee before termination is effective.
Perfect.
Meaning that the mere violation of the standards manual may not be a material violation. Nevertheless, the franchisor's brand may be hurt very badly, and maybe there's a monetary remedy for the franchise.
Then it's material by definition of material. If it's going to be it's material.
But Jeff, this stuff can bite you. I mean, first of all, what Craig said is right. When you have an underperforming franchisee or somebody, you just can't get with it. You know, what the franchisors don't immediately terminate and say get out of here. What they will generally do is they sell. We'll give you notice termination, but we'll delay it for 60 or 90 days while you sell your business to another approved franchisee. But let's talk about these good cause laws. And here's a radical example, but a true one. And it just took place, and we're in the middle of it now, where you have a, I don't want to be too specific, a fitness, boxing, karate, judo, etc., training center that is geared quite specifically toward children. Everything from young children having a 2-year-old birthday party and running around in karate outfits to teenagers. And there was a franchisee of this system in New Jersey who we received word and a complaint, who invited a 6-year-old child to sleep over at the facility, which is strictly forbidden under the franchisor's rules, a couple of times, and took the child and another friend of his on a trip to Disney World, just the two of them and the child. Okay. And so, you know, and the mother, of course, is absolutely freaking out. And we had to get rid of him right away. We can't keep somebody in there who's an image.
You were right or you were right. Either you were right or wrong. If it was material, then you were right. If it was immaterial, then you did it anyway to protect.
No. But you got to understand. Under New Jersey, I couldn't get rid of him, and I knew.
Why was that?
Because you can't terminate except for good cause.
That's right. There's good cause.
And until I can prove it, I don't have good cause.
Yeah, sure. You can get. Why did you go for an injunction?
Well, the bottom line was we knew. And by the way, even if I had good cause, I had to give him 60 days notice. And I wasn't leaving this guy in there for 60 days. And the client and we conferred and we said, look, if they sue, and they did, we're simply going to go into court and say to the judge, yeah, we know we violated the 60-day notice provision of the New Jersey Franchise Practices Act governing termination. We know that. We also know we had a franchisee who was either grooming or going beyond grooming with a 6-year-old boy and taking him alone with another individual.
So what was the problem? You had to pay for 60 days of damages?
At the end of the day, this was a risk we were willing to assume.
Right.
All right. If the judge wanted, you know, I was going to say very honestly, Judge, you want to put this guy back in and expose him to, pardon, that's a bad choice of words, put the fellow back in proximity to young children again, you do it. But we're not going to.
But that doesn't wash out all the other reasons why why you can't just terminate at will.
But you can't. You can only terminate. Listen, under contract law, you
What's
can't
wrong with
terminate at will.
What's wrong with having a materiality requirement? The fact that you were unable to, I don't see how that's not material. I don't know how you ran the case.
It's the notice. It was a 60 days notice. Look,
So
you're
then go in and get some sort of other type of creative injunctive remedy during that 90 days, because it seems to me that the fact that it's not in the statute, we could all sit here and come up with some type of remedy. But finding one particular way that this doesn't work doesn't throw out the rest of the 60-day remedies.
Well, I don't
Professor,
know.
I want to apologize to the professors here because I'm going to exercise the professor's prerogative and change the facts. Instead of this fact, I'm going to have an eatery where the franchisees will not, in New Jersey, but the franchisees will not introduce the new signature product, which is not halal consistent. The new product is a sausage breakfast item, and the franchisee in New Jersey will not handle halal, a sausage breakfast item.
Why
the
not?
purpose of contract in common law, in the common law world, is that the contract is king. We have bright lines about what someone's supposed to do, and they're supposed to follow the express terms of the contract. And one of the express terms is that when we introduce a new product, you will handle it if you want to be a franchisee. Now, when you take that to court and the franchisee says, this is against my religion, the answer to that question today might have been different than 10 years ago. Now we have enhanced religious preferences in courts. So this is the problem with trying to establish materiality in the abstract. People should know the rules, but what are the rules if you're going to insist on materiality? Or does every issue of termination go to a court now because we can't define materiality well enough?
Do you think a number of these cases, though, they balance out? You have what many of us have talked about in terms of contracts, which maybe terrorize at least some franchisees. And then you have good cause statutes, which maybe terrorize some franchisors. And there's a broad swath in the middle of behaviors where you just act fairly and you sort of say, okay, maybe we could do things, but this good cause statute, maybe we need to be a little bit more careful in terms of how we choose whether to terminate or not renew or whatever. Just like franchisees maybe are sometimes terrorized on the other perspective, looking at their contract. Do you understand what I'm saying? I mean,
sure.
It sounds like in a lot of these cases we're mentioning the worst case scenarios, which are pretty darn horrifying. I mean, what could be worse than grooming a child? Things like that. Or franchisees which are, taking advantage, or franchisors. But the broad middle, if one side has too much power over the contract, maybe the other side uses the good cause statutes or common law protections, constitutional protections, what Craig is getting at there, maybe with respect to religious preferences, and it evens out, at least for the broad swath in the middle.
This reminds me of a joke. When I was younger, I lost cases I should have won, and now that I'm older, I win cases that I should have lost. So all in all, justice has been done. What you're saying is maybe we leave it to the courts to do justice in a rough justice fashion. Yeah. Our concern as litigators who typically represent franchisors is maybe the legislature or even the regulators put their thumb on the scale sometimes with the definitions. And what I hear you saying is that the court should be flexible in contract interpretation, perhaps.
Yeah. Yeah. And the big problem is the cost of that in terms of the calculus that people have. Does it really reflect in what Audie was mentioning, which I really like, is hopefully that will inform bargaining power and people will incorporate that into their analysis. But I'm afraid that in a lot of cases that just doesn't happen. It doesn't bleed all the way through to people now looking at this body of law and coming to some common sense interpretations of what it means.
I'll tell you what could be one of the biggest impediments, and I'm not going to be particularly popular among some of my colleagues representing franchisors for saying this, but I'm hearing this through franchisees and their counsel in informal discussions. One of the biggest impediments is mandatory arbitration. It's one thing for a franchisee to be able to get an attorney and go into court. But when you go into arbitration, that franchisee has to start fronting out 3 arbitrators, charging $700-800 an hour, times 8 per day. It's not faster and cheaper anymore. It used to be, but it's not faster. It's not cheaper. It's not less formal. The discovery process is just as protracted. But the cost of paying the arbitrators on top of everything else really militates against many franchisees. Our advice to our clients around here is arbitration is a problem for franchisors. There are no rules of evidence. Any testimony comes in, and arbitrators don't have to follow the law. You have to prove they're in reckless disregard of the law and go try that. Most vital thing that concerns us is decisions of arbitrators can't be appealed. And for that reason, we say if the dispute involves 150,000 or less, arbitrate it. Otherwise, get into court where you have protections, the rules of evidence, and the right of appeal. But for franchisees, I think it's even more compelling that if they want to pursue what they see as justice, they not have to expend tens and tens of thousands of dollars on arbitrators' fees on top of their own lawyers' fees.
I'm glad you said that because that reflects what I felt as an expert. The few times I've been an expert in arbitration or litigation, I basically had to think back, is this in litigation or arbitration? Because I didn't see some of the vaunted difference. It's also what I've been teaching in classes for a long, long time, that you really have to think through, what are you actually getting from arbitration versus litigation?
Let me jump in for a last question because I know people have to run. I love this. This is a lot of fun. And here's a short answer question. Should there be any limits, legal limits, on what a franchisor can do with their system standards manuals? And if it's yes, then what should it be? If no, then fine. So, David.
Absolutely not. There can't be. Absolutely not.
And one sentence, why is that?
Now, let me explain.
Okay.
And you just saw this. When COVID hit in March of 2020. All right. We had clients who had to turn on a dime, who had to revise standards, who had to impose new policies, who had to come up with new products and have them marketed, advertised, and promoted. One of the greatest things we saw was Taco Bell within a month of COVID, and nobody could go out. You remember how bad it was in the beginning? Nobody could step outside. Nothing was open. They came up with what they called Taco Bell in a box, a way of creating a Taco Bell restaurant at home. And in the box, there would be the shells, and the meats and the sour cream and the toppings, et cetera, and some whatever that blue drink is called. I forget. Don't tell on me. All in a box so you could create the Taco Bell all in a month. But then, they had to mandate it being carried. They had to quickly come up with the supply chain that was going to satisfy this new product. The advertising, marketing, working with franchisees, et cetera, how to produce it, how to present it, and so forth. They had to turn on a dime. You can't. They were not restricted, thank God, or else they couldn't respond. They just
were they reasonable? Were they reasonable changes?
Depends on your perspective. To some franchisees, nothing.
I'm going to say they were reasonable under the circumstances. So to
some franchisees, Jeff, nothing is reasonable. I mean, one of the sorriest examples I saw.
Don't say things like that.
Involved. I said to some franchisees, not to all, to some.
Some.
One
of the most startling things I saw involved a soft serve ice cream franchisor. You guys know it. And at the time, they had 750 units up and down the East Coast. And because of the way society had changed in the late 90s, where women were working increasingly, and to this day, women work, and still 95% of shopping for the home is done by women. That should change, but it hasn't. All right, which is why you saw, as opposed to days where somebody would go to the bakery for bread, and the grocery store for canned goods, and the fish store for fish, and the butcher for meat. Now it was all in a supermarket because moms only had one day, and that was Saturday. And so everything was aggregated there. And these standalone soft serve ice cream stores were just having a difficult time. And so at the end of the day, this franchisor came up with a program where they put the product in supermarkets, ice cream cakes, and came to the deal with the major supermarkets that the franchisees would actually make the cakes. The franchisees would deliver the cakes. The franchisees would make all the money on the cakes and just pay royalties. But franchisees in this system, we don't want to do that. We're used to operating our stores. We don't want to spend any money doing anything new. We don't want to. And the chain dropped from 750 units to fewer than 300 in a period of 10 years. It was sometimes franchisees can get in their own way, not knowingly, but inadvertently.
So based on those anecdotes, you've determined on those anecdotes, and it's fine, that there should be no limits. That's cool. All right. Adi, what do you think?
I would agree with David, subject to ex post analysis or reasonableness analysis by a judge. So I'm really worried about anyone coming and giving not really a good reason for doing something that can hide under a system standards requirement, which actually is some other form of opportunism. And I would like some third party to look at that, rather than just decide up front if it's allowed or not.
That seems a lot different than David's, though. I mean, David's saying absolutely. Yeah. And you're saying, I agree with you, that there should be some type of reasonableness analysis.
Yeah.
Craig, I know where you're coming out. Yeah. Well, maybe I don't.
No, I don't know. I'm in the reasonableness place, but we have to be careful here. Because let's say I'll give you a hypothetical, the professor's hypothetical. The franchise is an educational, a childhood educational place. They teach math after school. And the math franchisor is taken over by private equity. And private equity mandates in the manual that all of the locations must now have a kiosk where they sell toys, educational toys, and non-educational toys, because the private equity company owns an affiliate that makes toys. And certain franchisees rebel against this because they want to teach education. They don't want to teach toys. So sometimes you see that the system changes, not because if they don't change it, it's going to be a museum and they're not meeting competition, but rather that there's another agenda. And it's one that the franchisees may not appreciate, but the owner of the franchisor appreciates more. So that's the continuum of changes that you might see in a manual.
Right. So I think your position would be that there's some discrete level of reasonableness analysis, but it wouldn't be a free-ranging one. You'd probably articulate. It wouldn't be a full-blown good faith covenant of good faith and fair dealing, it would be limited in some way, or maybe not.
The example I always use with clients is that if you looked at the McDonald's menu from 20 years ago, you would not see the variety of foods that you see now. And that is how McDonald's has to change in order not to become a museum and to meet competition and to cater to their customers. And those are the kinds of changes which are best. I've seen other changes of changing other systems through the manuals because they can't change the agreement, which do fundamental violence to the agreements. So I'm against fundamental violence to the agreements. I am in agreement that broad changes to the manual and the way of operation should occur for modernization.
Good. Quick legal question. We're almost
Well,
finished.
can I?
Yeah, I'm gonna bring you in one sec. Quick legal question on this. Do you think that when franchisee franchisor sign an agreement, and then you have a manual that can be at will modified, don't you think that the expectations that those parties used initially have been totally destroyed? I mean, how can you still support those changes as being within the scope of the initial agreement? Totally outside the expectations at some point of what the individual franchisee bought. Just like you can't change a price, for instance, or a fee. At some point legally, you can't make a choice. And courts don't distinguish necessarily between changing a price or a fee or something in the franchise standards manual. They see system standards manual. It's like a magic wand. Oh, system standards. It could be much more impactful on the franchisee. So I think there's a legal problem, putting aside the economics. But let me run because I know everybody's got. Robert, you had a last question. I mean, a last answer to our last question.
Yeah. To go back to what everybody said, I think there was a lot that I could agree with. I would just add, I think you mentioned this maybe, Jeff, the notion of competence, and the way I've tried to deal with it in some of my writings is this whole question of know-how, the continuing know-how that franchisees often have a right to expect that the franchisor is going to dispense. That's what makes it more than just licensing something or having a distributor. You've got an ongoing relationship. And so if you tie in sort of this notion of can they make changes unilaterally? Yes, but with sort of the caveat that Adi had, and perhaps Craig, that you've got to qualify it with a number of things. Are they, does this comport with sort of their notions of how the know-how is to be transmitted, and how is it affecting the goodwill that the franchisees may have been garnering for the system as a whole? And that's why I find that sometimes we can learn a lot from comparative law and looking how other systems have tried to deal with concepts like savoir-faire or required provision of payments for lost goodwill, that sort of thing. And if you can tie that in, then I think you give the freedom still to the franchisor, but it's bounded by the expectations, reasonable expectations that the franchisees have when they buy into the system.
Yeah.
But I'll be brief. I'll just remind everybody of some ancient history which may be useful to this dialogue. The McDonald's system nearly fell apart. It was fractured in the 70s. The franchisee, McDonald's said, we're doing something new. And the franchisee said, no way, that's not what we do. We're beef guys. We do lunch and dinner. We're not doing this. It'll be an extra shift, extra hours, new products. We have to learn how to make them, et cetera, et cetera. And you know what the new concept was? Breakfast.
Yeah.
And which has proven to be one of the most profitable day parts for McDonald's franchisees. But at the time, it would have seemed perhaps unreasonable for McDonald's to say, okay, burger people who are open lunch and dinner, now open for breakfast, hire another shift, learn to make new products, get sources, come into our supply chain for sources for eggs and English muffins and cheese, et cetera, et cetera. It would have seemed unreasonable.
Yeah.
But not if they had done a study.
But
Just to make it, if they had done a study before, it wouldn't have seemed that unreasonable.
yeah, and a lot of the case law out there, Canada, France, other places, and in the U.S., I'm sure, would say that after the fact, as you look at it, if there's ever a challenge, as long as the franchisor had the kind of the guts or temerity to go forward, do a study, hopefully ahead of time, the fact that some recalcitrants were just not going along with it is not going to really protect them, I think, legally. The system, even the pro-franchisee systems that you may find with some comparative law analysis are not going to justify, in the end, franchisees who really are not looking at the big picture.
Right.
And there's even case law that says even if you're screwed over by the decision of the franchisor, if it's good for the system as a whole, that's typically going to be satisfactory.
Except, Robert, the problem was at the time nobody knew if it would be good for the system.
Oh yeah, no, I understand.
I don't know that they did any in-depth studies. They may have had some test marketing of the products and see if people liked the way an Egg McMuffin tasted, et cetera, et cetera. I really don't know if they did any broad-scale studies before introducing breakfast, but I do know that they invented a day part that proved enormously profitable, but at the beginning was met with harsh resistance.
Yeah.
Well, thank you all. This has been fantastic. I loved it. You guys are perfect for the panel. Thanks for coming. Thanks for doing it. I know a lot of people are shooting out the Passover. Thank you, David, Adi, Craig, and Robert. I had a great time and a lot of fabulous insights and small disagreement. Thank you.
Thank you very much.
Thank you very much, Jeff.
Thank you.
Thanks so much.
Yes.
I'd like to say a thank you to Jeffrey and a big thank you to all of our panelists today. This concludes this 2023 Legal Eagles Virtual Summit panel. I'd like to thank all of you for tuning in to this and all of our other panels and hope that it's given you all the insight you need when it comes to the world of franchise law. We hope you join us again next year for more Legal Eagles coverage. Good day.